that the Modi government approach to the judiciary smacks of the three I's, I, and I, where the three I's stand for intimidation, interference, and influence. These unfortunately have become the insignia, the notorious spikes of this government. The ruling party in this government can equally be accused of the three S's: an attempt to sabotage, subjugate, and subvert the judiciary. So this deadly combination of the three I's, intimidate, interfere, and influence, along with the three S's, to subvert from within unnecessarily by all kinds of antics the judiciary, is deplorable. When a bench of the Supreme Court made strong and directly pertinent observations for the simple reason that the person concerned in the Nipur Sharma case was seeking relief of the court. When they made directly pertinent observations regarding the conduct of that person seeking relief, namely Nipur Sharma, we saw three-pronged attack. And this three-pronged attack is the signature campaign of the BJP, all too familiar. One, savage and faceless trolls spewing fake news and propaganda immediately started. Second, an orchestrated letter by so-called intellectuals. And three, a one-sided and contemptuous reporting planted in large sections of the Godi media. The large silent majority stood by this vital, possibly most fated and supported organ of governance, the judiciary. But a sitting judge of the Supreme Court, Justice Pardiwala, was forced to observe, and I quote, "Attacks attempted at our judges for judgments will lead to a dangerous scenario where judges will have to pay greater attention as to what the media thinks rather than what the law actually mandates. This puts the rule of law on the burner, ignoring the sanctity of the respect for the courts," unquote. Please juxtapose this statement of a sitting Supreme Court judge with the kind of trolling attacks which happened immediately after the bench dealt with that case. We have, friends, over the last 7 years seen egregious executive action on flimsy grounds, usually invoking inapplicable provisions like sedition, like UAPA, the most draconian they can find on the book. The biggest defaulters in this misuse of provisions, inapplicable provisions, has been the central government. Equally, they know that the process is the punishment. The end result be damned. The process is the punishment. Tardiness or hesitation of courts through bail intervention in such contexts exacerbates this bad situation. Hence, friends, the relevance of yesterday's judgment. The Supreme Court yesterday has said that the lack of speed in dealing with bails, as also a hesitation to grant them, would, quote unquote, make India look like a police state. The Congress believes that this is much needed guidance from the Apex Court about the approach to bails and about how bail, not jail, being the norm is operationalized in practice. It is sad to find that a fact checker, the person under arrest is a fact checker. He simply checks facts and says, this is a false claim. The entire army of law officers was put out by the government to oppose bail matters, qua this fact checker. The entire army of law, senior law officers was saying what? They were saying, in a worse case than shooting the messenger while ignoring the message, they were speaking in defense of those whose illegal conduct had been exposed by that fact checker. It was a sad sight. They desperately and sheepishly opposed the bail on grounds that were far removed. For example, it is reported and well known, some of us were in court, one of the arguments of the state was that the sentiments of followers had been hurt by having a seer's hate speeches exposed. So you give a hate speech, so-called seer, I expose it by a fact check or by showing it, and my exposition or my exposure will hurt your feelings, is the argument officially orchestrated by this ruling party and the government, is that all of this is part of a grand shady conspiracy. Such small-minded and outrightly unconstitutional claims expose this government and its defenses in court. The learned sitting judge of that court just yesterday said, and I quote, I am quoting, mind you, a sitting judge told me that he had received a call from Delhi, bracket name not disclosed. The person from Delhi asked about me. I told him that I am not affiliated to any party. He said that the additional DGP is from North India and he is very powerful. The High Court judge said, adding that a reference was also made by that judge who talked to this High Court judge regarding transfer of another judge. This has been quotes. Honorable Justice Sandesh, who said this in courts, added that he had reported this perceived threat to the authorities. And he said that it amounts to a direct interference in the independence and of the judiciary and dispensation of justice. This is only symptomatic. I have given you 6 categories of the antics, the tricks, the shenanigans adopted to do this for the last 7-8 years.